Exactly right. So, I mean, it is, in fact, I would say perhaps dangerous as a matter of public policy to tell people they are allowed to use force against officers when the arrest is unlawful.
But we
Because
have
everyone's going to determine the arrest is unlawful. I cannot emphasize that enough.
We are the Armed Attorneys. Today we're talking about kind of a sensitive subject when it comes to using force in self-defense against peace officers or police officers. Now we're going to be talking about what the model rules say, kind of some exceptions that we see in other states, and ultimately what is the standard that is applied at trial when juries are asked to evaluate, hey, was your use of force against a police officer justified? But before we begin, show your support for the Second Amendment by hitting that like button. And we're in a election season. Make sure YouTube hasn't unsubscribed you. Check your subscription status. We've gotten that complaint from quite a few people. But to start off the conversation, using force against peace officers, I can already hear the comment section.
I can, because y'all always get real mad about this. And I get it. We have a diverse viewing population, right? We've got lots of law enforcement viewers. We've got lots of people who are like, F the Galveston police, as one of my criminal defendants many, many years ago once said. I get it. This is touchy. However, it is coming up more and more because, unfortunately, you start to resist arrest. Probably going to get your butt kicked. And then there's going to be lots of lawsuits and fallout, and the media loves to eat that stuff up for breakfast and put it all over the news. So we see it all the time. It's happening right now all over Texas right now.
Yeah, and what kind of sparked our discussion here, we had a colleague, Colin Keene, give him a shout out, great lawyer in the area, recently received a not guilty verdict in a case involving an assault on a peace officer. And so we had to go diving into the law a little bit to see how did we get here, because that is not a typical result.
It is not. And why is that? Because for everyone who resists arrest, like, I don't know, and I would say 95% of the time I look at it and I'm like, buddy, like, you're probably drunk, first of all. And that was, I mean, everyone's like, it's an unlawful arrest. It's an unlawful arrest. But like, in the same way that I've never been the wrong one in an argument with my husband, I'm sure you are always going to think your arrest is unlawful. You're never going to be like, you got me.
Yeah, and so when we look at our model penal code, I mean, some states go directly off the model penal code. Pretty rare. It's kind of a, hey guys, here's something to model your state's law after, and so we see it as kind of persuasive. It's taught in law schools, but beyond that, but when we look at the model penal code and we look at laws across the United States, we do see some differences. And our model penal code says, hey, guess what? It is a limitation on the justified use of force to use any force against a peace officer, regardless of whether the use of force is, or the arrest or search is lawful or unlawful. So
Right.
they say you can never do it.
Right. And again, I'm going to reemphasize that it is really hard to ask you, the individual in the moment, to determine whether or not your arrest is lawful or unlawful. Nobody wants to get arrested. So that is why we do not use that as the standard.
Yeah, the determination's made in a courtroom, not on the side of the road.
Exactly right. So, I mean, it is, in fact, I would say perhaps dangerous as a matter of public policy to tell people they are allowed to use force against officers when the arrest is unlawful.
But we
Because
have
everyone's going to determine the arrest is unlawful. I cannot emphasize that enough.
But I mean, we do have a smattering of states. We're going to use Texas as an example here, where we say, guess what? Okay, we have this general rule, and we have a line of cases that says, hey, guess what? It doesn't matter whether the search is lawful or unlawful. That we can completely put that to the side for the moment. But we have some statutes that will say and have, kind of a limitation to the limitation, saying, if your use of force is to respond to a peace officer's use of force that's greater than necessary to effectuate the arrest or search, even before any resistance is offered, then that, you defending yourself. I mean, I just have a clear example in my head. I had a police officer in a local jurisdiction here, had a frequent flyer, familiar with him, knew that his license was expired, pulled him over. The guy completely polite to the officer. And for kind of no reason, the officer rips him out of the car, throws him to the ground, and I mean, way excessive force.
Sure.
So, I mean, that might be one of those scenarios, no resistance is offered at that point. If he were to use force to, I don't know, maybe prevent serious bodily injury or death. I mean, getting thrown to the pavement, having your head hit, one of those little parking spot things, that can kill you.
Yeah.
Would that be justified potentially?
I think it would. Now, the issue here is, right, we're talking about officer uses force against you. It is over the top, disproportional, unlawful force. You use some force in return. Well, you're not going to be convicted of assault public servant because it was justified use of force. But the problem, just practically speaking, is once you ratchet it up and use force against that officer, you are going to get your ass whooped. I
Yeah.
mean, you're going to get tased, you're going to get beat to all hell. And that's really hard because then who's going to save you? You don't have the gun.
Yeah, it's a really tough
I mean,
scenario.
honestly, I mean, that it is with people getting shot
Yeah,
potentially, you know?
but hopefully, and I mean, I guess this is what we're really trying to get to is, there is a scenario where a use of force, and depending on your state's law, may be justified because really, it's that last resort, and juries will still be asked to evaluate whether or not your actions were reasonable and immediately necessary, and in connection to what is the officer doing and how are you responding. But just knowing that the door is not completely shut on it, in some states, I think that's important to know.
It is important, although I very much hope that no one who is watching this ever finds himself there because nobody wins. Nobody wins in that scenario.
But the last kind of question that I think is raised here is, and this applies to all self-defense cases, and speaking to the attorney that handled this case, this is, chef's kiss, whenever you don't really get to communicate with a jury, directly. The way that they communicate with the court is they send out notes. The court brings everybody in. They all sit down. The court reads out the note, and then the parties decide on how they're going to respond to this. And he got an incredible note, which was, does the state have to disprove self-defense beyond a reasonable doubt? That makes my defense attorney heart happy.
That's good. And that's how you get them too. That's how you get them.
And that's the standard by which juries should be looking at self-defense cases.
Yes.
The burden initially, in most cases, is going to be on the self-defender to produce some evidence that what they did was a self-defense act. Well, at that point, now that the defense theory is out in the ether, the burden is then on the government to prove beyond a reasonable doubt that you did not act in self-defense. And I mean, that's the highest standard we have in law.
It is. One time I convinced a jury that the government had to bring them like physical evidence that disproved self-defense beyond a reasonable doubt. Somehow, I don't think I said those words, but they came back with a not guilty verdict. And afterwards they were like, well, where was the video that showed it wasn't self-defense? The government didn't show us that. And I was like,
You did your job.
all right.
Well, like, think about the Robert Durst case. If y'all aren't familiar with that, check out The Jinx. I think that's on HBO. It's a really fantastic series. But I mean, the defense there was the government didn't have any evidence that the defendant's finger was on the trigger.
Yeah, that's a tough case in this part of town.
Yeah, that's one of those. I mean,
know.
that's where we live.
I know. March into Galveston County and be like, what up? You watch The Jinx? Because all the prosecutors down there are like,
Salty?
a little salty.
Yeah.
Yeah.
But I'm interested to see what your state's laws have to say on this stuff. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. Until next time, we're the Arms Attorneys.